Welcome, welcome, welcome to The Deep Dive, your personalized shortcut to being well-informed. Today, we're embarking on an exploration into a truly critical and, at times uncomfortable topic. It really challenges a fundamental narrative many of us have grown up with. You know the one. The idea that Australia's national wealth was simply built on the bedrock of hard work and merit. Instead, we're going to open up a stack of sources that reveal a different, far more complex and frankly disturbing truth. We'll be looking at how the violent dispossession of Indigenous peoples wasn't just a regrettable side note in history, but a foundational act, an act of what historians and economists call primitive accumulation. This systematic, often brutal seizure of land and resources directly laid the groundwork for private property as we know it, and indeed for the very national wealth Australia enjoys today. Our mission is to unpack the intricate historical and legal processes that enabled this. We'll focus on how specific state policies, the deliberate denial of treaties, and the creation of reserves served to violently clear vast tracts of land.
Yeah, cleared for burgeoning industries like mining and agribusiness.
Exactly. And this isn't just dusty history confined to textbooks. Our sources indicate it's a continuous crime, one that underpins the entire economic system right up to the present day.
It's undoubtedly a heavy topic, yes, and one that absolutely demands our careful, critical attention. What's truly fascinating and often overlooked is how this deep dive will meticulously connect the intricate legal frameworks of the past and present, the evolving international human rights discussions that are gaining global traction, and the stark economic realities faced by Indigenous communities in Australia.
Right.
Understanding these deep historical roots is not just about historical accuracy. It's essential for grasping the profound ongoing implications that reverberate through our modern world, shaping everything from land ownership to wealth distribution. It's about connecting the dots to see the full, uncomfortable picture of how wealth has been, and in many ways continues to be, accumulated. And when we talk about primitive accumulation, we're really talking about the violent, non-market processes, often state-backed, that forcibly separate people from their means of subsistence and land.
Forcibly separate them.
Yes, creating the initial capital and private property necessary for the development of a capitalist economy. It's a foundational act of dispossession.
A foundational act. Okay, so let's unpack this, starting right at the beginning, the very beginning of European settlement. Our sources point out that British colonization of New South Wales effectively began when Captain Cook arrived in 1770 and claimed the eastern coast. Just to put that in perspective for you, our listener, that's more than 280 years after Brazil's colonization by the Portuguese began. This wasn't just a leisurely stroll onto an empty continent, was it?
Absolutely not, no. This brings us directly to a pivotal and deeply problematic legal concept, terra nullius. It's a Latin term meaning land belonging to no one.
Land belonging to no one.
Precisely. This was the prevailing legal fiction that allowed Britain to acquire sovereignty over Australia. In essence, it was a declaration that the land was uninhabited, or, crucially, had no recognized legal system of ownership. This was despite the vibrant, complex Indigenous societies having lived there for over 60,000 years, with their own sophisticated laws, customs, and intricate connections to the land.
60,000 years.
This legal sleight of hand was fundamental to justifying British claims. It persisted for centuries, acting as the legal bedrock for colonial expansion. It provided the convenient excuse for wholesale appropriation. It's important to remember that it was only explicitly overturned by the High Court of Australia in the landmark Mabos No. 2 judgment in 1992. We'll definitely get into that later.
Yeah.
But for a very long time, this fiction allowed the British Crown to assert not just sovereignty, but full beneficial ownership.
Full beneficial ownership. Can you explain what that means exactly?
Sure. It means the complete unrestricted right to use, enjoy, and transfer the land as if it were private property. It effectively extinguished any prior Indigenous rights. The depth of this denial is starkly illustrated by the fact that Indigenous Australians were not even counted in the national census until much later in the 20th century.
Not even counted.
They were, in essence, rendered invisible in the official records of their own land.
So for you, our listener, what did this foundational legal fiction, this declaration of an empty land, truly mean for the Indigenous populations already living there? Populations with their own complex societies and profound spiritual and practical connections to the land.
Well, for them, it meant violent dispossession, a relentless assault on their existence, and the systematic dismantling of their way of life. From 1788, when the first fleet arrived, until about 1830, the British government primarily ran Australia as a penal colony.
Right,
Exactly. But after 1830, the policy significantly shifted. It moved to systematized colonization, actively bringing in free finance settlers, complete with land grants and incentives. But, and this is key, this didn't mean an end to forced labor. Indigenous people were still conscripted or coerced, with forced labor continuing until as late as 1868 in some regions.
Okay.
And until the 1880s, the relationship between white settlers and Aborigines was characterized by a brutal, often unwritten policy of pacification by force. This wasn't just a euphemism. It involved massacres, poisoning, violent displacement, all driven by a deeply troubling ideology.
Which was?
The pervasive belief that indigenous populations would simply disappear as colonialism advanced, either through disease, violence, or by being bred out. This wasn't passive neglect or a slow erosion of rights. It was an active and often genocidal process of displacement, extermination, and oppression aimed at their eradication.
To clear the land.
To clear the land for settler enterprises, yes.
That's a chilling detail. The expectation of indigenous people simply disappearing. It sounds strikingly familiar to other settler colonial histories. Could you draw some parallels, maybe, to the United States experience? Similar justifications and policies were implemented there, too, weren't there?
Indeed, there are significant parallels. They really highlight a broader, systematic pattern of settler colonial expansion aimed at, well, primitive accumulation. In the United States, for instance, the policy of recognizing Aboriginal title and signing treaties with Native American nations that was repudiated by the Senate in 1852.
Repudiated.
And then formally abolished by Congress in 1871. This marks a profound and devastating shift from a sort of nation-to-nation relationship to one of outright subjugation.
So what replaced the treaties?
What replaced treaty recognition was an effectively genocidal open season. That's how some sources describe it. During this period, the state of California, for example, even went as far as paying volunteer militias that actively engaged in the enslavement or extermination of California Native American peoples. This was state-sanctioned violence, directly contributing to the primitive accumulation of land and resources.
State-sanctioned? Wow.
And further legislative action followed. In 1863, the U.S. Congress legislated to prevent Native American tribes from suing the government for treaty violations, effectively removing their legal recourse. Then, the Dawes Act of 1887 broke up communal reservations into individual allotments, a policy designed to assimilate Native Americans into a Western concept of private property, while simultaneously shrinking their land base and making it easier for non-natives to acquire their lands.
Oh, a double whammy, really.
Exactly. And the U.S. Supreme Court delivered another profound blow in Lone Wolf v. Hitchcock in 1903. They declared that Congress could unilaterally cancel treaties with Native American tribes. Shockingly, the court described them as an ignorant and dependent race.
An ignorant and dependent race. That language.
It clearly demonstrates a systematic, multi-pronged effort to strip indigenous peoples of their legal standing, inherent sovereignty, and property rights, directly facilitating the expansion of settler wealth and territory.
That truly reveals a devastating, deliberate pattern. A systematic denial of legal standing, of humanity itself, whether in Australia or the U.S. It put indigenous people in common law, settler colonial countries in an impossible situation, didn't it?
Precisely. They were caught on what our sources call the horns of a dilemma, a legal trap with no escape. On one hand, any native title they might possess was often viewed not as an inherent right stemming from their ancient laws, but as a purely permissive exercise of the Crown's executive power, subject to withdrawal at any time. So it wasn't a secure, inalienable right, but a revocable privilege.
A privilege that could just be taken away.
Exactly. And on the other hand, the validity of any treaties they might have signed with the Crown was routinely denied. The grounds that indigenous people, deemed savages, lack the capacity to enter into such instruments or even possess coherent systems of law and property ownership at all.
So they couldn't make treaties because they were savages, but any rights they did have were just temporary permissions from the Crown anyway.
That's the self-serving circular legal logic. Purpose-built to justify wholesale dispossession and land theft, while simultaneously discrediting any indigenous claims to rights.
Yeah.
The stark reality is that these were terrible crimes, immense in their violence and scale. Our sources explicitly state that these acts of settler colonialism were precursors to genocide seen elsewhere in the world, methods that continue to cause impact in our modern world. The intention behind settler colonialism, whether in Australia, the US, or other similar contexts, was clear: to effectively liquidate, subjugate, and replace existing indigenous populations, creating new societies. Societies built upon the appropriated land and resources. This wasn't incidental. It was foundational to the entire colonial project, an act of primitive accumulation on a continental scale.
And this colonial foundation, this systematic invalidation of indigenous rights and lives, directly shaped how land and resources would be accumulated for the benefit of the new settlers. It set the stage for everything that followed.
Precisely. It was the initial violent act of primitive accumulation, forcibly clearing the way for the establishment of private property and the extraction of resources that would drive national wealth. It wasn't about developing unused land. It was about seizing already occupied and managed territories, stripping them of their existing owners, and reframing them as private assets for the colonizers.
Okay, so moving from those foundational legal fictions that justify the initial land grabs, let's turn our attention now to how these views were translated into direct state policies. Policies that further cemented this dispossession. This is where it gets, well, compelling. As we see abstract principles become devastating on-the-ground action, what were the first key policies that really escalated this process?
Well, this brings us to the formal creation of Aboriginal reserves. These were established across Australia, particularly gaining momentum in the late 1920s and early 1930s. Initially, the stated intent behind them was protection for Aborigines, a narrative spun to justify their removal from lands now desired by settlers.
Protection, that sounds noble on the surface.
On the surface, perhaps. But this purported protection masked a far more insidious ultimate goal: integration and, more chillingly, assimilation. This assimilation was often pursued through miscegenation, the forced interbreeding of different racial groups, conceived as a means to ultimately eliminate Aboriginality itself.
Eliminate Aboriginality by breeding it out.
Effectively, yes, by literally breeding out indigenous identity rather than protecting distinct cultures. It was a demographic strategy to erase a people.
That's horrifying. The Aborigines Act from 1905 to 1936 seems like a prime and frankly heartbreaking example of this policy in action. It gave the state immense intrusive power over indigenous lives. Can you tell us more about its specific provisions, particularly concerning children?
Yes, the act authorized the shocking state-sanctioned policy of removing mixed-race children, often referred to now as the stolen generations, from their Aboriginal mothers. They were transferred to white-administered settlements or foster homes. One notorious example was the Moore River Native Settlement, also known as Mogumber, in Western Australia.
Moore River, I've heard of that.
It operated less like a protective institution and more like a penal colony for Aborigines. It even had its own jail. And it served to intern those classified as indigent or troublesome from across the state, irrespective of age.
Child dumping ground, essentially.
In many ways, yes. Our sources highlight that many mixed-race children, often the offspring of white farm laborers and Aboriginal women, were forcibly transported, sometimes hundreds of miles, from the northern parts of the state all the way to the south, placed under the stringent, often arbitrary jurisdiction of the Chief Protector of Natives.
The Chief Protector.
This wasn't merely a separation. It was a deliberate, brutal, state-sanctioned rupture of families, culture, and identity, designed to sever the generational transmission of indigenous knowledge, language, and connection to land. The act's reach was chillingly pervasive. It dictated who indigenous people could marry, where they could live, even who controlled their wages. It stripped them of almost all personal autonomy.
Imagine living under that. A government protector having more legal power over your life than you did yourself.
Exactly. And this policy, and others like it, reinforced a system of deep discrimination and coercion within a nation that was actively practicing a racist policy of maintaining a white population.
So indigenous people were essentially stripped of their basic human rights.
Systematically. They were denied citizenship, a right automatically granted to white Australians. They were also denied normal legal rights. Instead, they were subjected to the whims of supervisors, missionaries, or local farmers who held broad, unchecked powers of judgment and incarceration over them, operating outside the standard legal system.
Wow.
Their participation in the national economy was largely confined to seasonal and itinerant manual labor, often exploited, paid in goods or negligible wages, if at all. Crucially, they were explicitly excluded from the Social Security system, a benefit strictly restricted to white Australians, cementing their economic marginalization.
The discrimination was just everywhere then.
Pervasive and institutionalized, affecting every aspect of their lives. Freedom of movement was restricted. They often needed permits to leave reserves. Access to education and healthcare was severely limited. And this was all occurring in a nation that touted itself as a democratic beacon, yet practiced such extreme racial segregation and control.
It's hard to reconcile those two things.
Very. Even as late as the 1960s, Queensland explicitly excluded itself from measures that sought to annul discriminatory acts against Aborigines, underscoring just how deeply entrenched these policies were. It wasn't until the 1967 referendum that Indigenous Australians were even counted in the census or the federal government gained power to legislate for them.
1967, that's relatively recent history. So when we look at the bigger picture here, this wasn't just passive dispossession or a slow erosion of rights. This was an active, violent, and utterly systemic dismantling of Indigenous societies and their profound connection to land, all designed to clear the way for colonial expansion and resource exploitation, correct?
Precisely. It was a deliberate, calculated strategy of primitive accumulation. The establishment of reserves, the forced assimilation policies, particularly the removal of children. These were all mechanisms of social and cultural control. They complemented the legal fiction of terra nullius. The goal was not just to take the land, but to eliminate the people and their claims to it.
Ensuring the resources could be freely accumulated.
Yes, ensuring that the vast resources of the continent could be freely accumulated by the settler society without challenge. This was primitive accumulation enacted through state-sponsored violence and policy. It laid the very groundwork for the private property system and economic structures that exist today, and from which immense wealth continues to be generated. The impact on Indigenous communities was, and remains, catastrophic.
Okay, so that brings us to a potential turning point. The legal landscape in Australia saw a seismic, truly monumental shift in 1992 with the Mabo No. 2 decision. This must have felt like a genuinely transformative moment after centuries of denial.
It absolutely was a landmark ruling. On June 3, 1992, the High Court of Australia reshaped the legal understanding of land rights forever. The court found that native title existed in Australia and, critically, that it had survived the Crown's acquisition of sovereignty in 1788.
It survived. That's huge.
It meant that the Crown, while acquiring radical title, that's the ultimate overarching power to grant interests in land, the foundation of all land titles did not acquire full beneficial ownership of all Australian lands. That distinction, remember, the full beneficial ownership being the unrestricted right, that distinction was pivotal. It acknowledged someone else could still hold rights.
So the Crown didn't own everything outright.
Correct. The decision explicitly overturned the concept of terra nullius, declaring it a legal fiction. It recognized that the Meriam people of the Murray Islands, led by Eddie Mabo, continued to occupy their traditional lands. The court affirmed that they were entitled as against the whole world to possession, occupation, use, and enjoyment of the lands, a profound legal acknowledgement. Indigenous laws and customs regarding land predated and survived colonization, a direct repudiation of the colonial lie.
That sounds like an undeniable victory, a truly transformative moment, as you said. But I gather the path to this judgment wasn't smooth. It was fraught with immense challenges, resistance, even before the final judgment. What efforts were made to undermine it?
Indeed. The path was very difficult. The Queensland Parliament, for instance, in a blatant attempt to preempt the Mabo case, enacted the Queensland Coast Islands Declaratory Act in 1985. This act purported to declare, retrospectively, that upon annexation, the Murray Islands were vested in the Crown, freed from all other rights, interests, and claims. It basically tried to wipe the slate clean before the court could rule.
And just declare no compensation payable either.
Exactly, no compensation payable. It was a clear attempt to legally extinguish any potential native title before the High Court could rule on it. A desperate move by the state government.
But that didn't stand up, did it?
No. In a preceding case, Mabo v. Queensland No. 1 in 1988, the High Court found this Queensland Act invalid. The court ruled it was inconsistent with the Commonwealth's Racial Discrimination Act 1975. That federal law prohibited discrimination based on race.
Ah, so federal law offered some protection?
Yes. That earlier decision was crucial. It prevented Queensland from unilaterally extinguishing potential native title rights without recourse and laid the groundwork for the 1992 victory.
So, Mabo No. 2 truly broke new ground, recognizing that Indigenous peoples across Australia continued to hold rights to their land and waters, arising from their traditional laws and customs. What was the key condition for these rights to actually be recognized by the courts?
The High Court specified a critical condition: For native title to be recognized, those traditional laws and customs must have continued to be acknowledged and observed substantially uninterrupted by each generation since 1788.
Substantially uninterrupted since 1788. That sounds like an incredibly high bar to clear.
It was and remains an incredibly challenging hurdle for claimants to prove. Colonization, with its massacres, forced removals, assimilation policies, it was explicitly designed to disrupt this continuity, which creates a profound irony. The very systems that caused the discontinuity then demanded proof of its absence for rights to be recognized.
Right. In direct response to Mabo, number 2, the Keating government passed the Native Title Act 1993. What did this act actually set out to do? How did it structure the future of native title claims and existing land interest?
The Native Title Act aimed to provide a statutory framework in the wake of Mabo. Firstly, it legally defined native title. Rights and interests possessed under traditional laws and customs, recognized by common law. Secondly, it protected native title from extinguishment by mechanisms contrary to the act itself, trying to prevent future arbitrary dispossession.
Okay, so definition and protection. What else?
Crucially, however, the act also confirmed the validity of previous land grants, existing forms of land title, and Crown actions that had occurred before its enactment. This was a significant political compromise. It effectively validated all the dispossession that had already occurred prior to 1993. It didn't undo past grants of freehold or leasehold land.
So it looked forward but cemented the past gains for settlers.
That's a fair summary. It also established the National Native Title Tribunal, the NNTT, as a body for claims and mediation. And it created a framework for negotiating government actions on land with potential native title of the future acts regime, and established liability for compensation for certain Crown acts between 1975 and the start of that regime.
A complex piece of legislation then, trying to balance a lot of competing interests.
Very much so.
So it attempted to create a legal pathway and offer some protection, but the practical application of the act seems to have revealed significant limitations almost immediately, making it very difficult for Indigenous communities to actually assert these rights. What were some key court decisions that highlighted these limitations?
Yes, the practical application hit major hurdles. A series of high court decisions in the early 2000s significantly narrowed the scope of native title. One major one was the Yorta Yorta case in 2002. This judgment held native title was extinguished if claimants couldn't prove that continuity of customs and traditions from 1788 without substantial change or interruption.
Without substantial change, despite everything that happened.
Exactly. Justice Olney famously wrote that the tide of history has indeed washed away any real acknowledgement of their traditional laws. This interpretation created that catch-22 we talked about, demanding an unbroken chain despite colonialism's efforts to break it. It made claims practically impossible in many heavily settled parts of Australia.
So the law essentially validated the disruption.
In effect, yes. Another highly influential decision was Western Australia v. Ward, also in 2002. This case characterized native title as fragile, a separable bundle of rights that could be individually extinguished. This decision indicated native title could be extinguished by Crown power, even if the land was unused by the Crown. So native title was likely partially or totally extinguished in national parks, nature reserves.
A bundle of rights that could just be picked apart.
That was the implication. And alarmingly, the High Court dismissed that native title constituted resource ownership and interest in land. It explicitly excluded valuable subsurface minerals. The reasoning: Aboriginal people had not demonstrated laws and customs related to the use of minerals, a huge blow to economic potential.
Excluding minerals, that's a massive in a country like Australia.
Absolutely. And then there was Wilson v. Anderson, also 2002. This found that perpetual pastoral leases, common in Western NSW, completely extinguish native title, unlike some other types of leases. These three decisions, in quick succession, severely narrowed the scope and strength of native title rights, often frustrating the hopes Mabo had sparked.
It seems native title existed, but its practical application was severely constrained, especially where it conflicted with established settler interests.
That's precisely the outcome.
This raises an important question for you, the listener. If native title is deemed fragile and can be so easily extinguished, if it's not even considered resource ownership, what kind of genuine security and true benefit does it truly offer Indigenous communities? It sounds like a right constantly under threat. Okay, this is where we see the direct, undeniable link between those state policies, the restrictive legal decisions, and the ongoing accumulation of wealth, particularly through resource extraction in Australia. It's a stark illustration of how the foundational injustices we've discussed continue to fuel modern economic power, a continuous engine of primitive accumulation.
Indeed. Our sources repeatedly highlight this. The wealth of the ultra-rich, especially in colonial contexts like Australia, is often rooted not purely in merit, but profoundly in favoritism, corruption, or monopoly power. There's a clear statement that such wealth has the mark of colonialism, and that extreme inequality is deeply rooted in the colonial history of extraction and abuse of wealth.
It's not just history, then. It's an ongoing structure.
Absolutely. This isn't just theory. It's a direct observation of how economic power structures are built and maintained, often by exploiting the very legal and policy frameworks we've been discussing. The primitive accumulation wasn't a one-off event. It's a continuously regenerating engine. Legal loopholes, power imbalances in modern agreements. They act as the new frontiers for wealth transfer, echoing historical dispossession.
So how does this play out specifically in Australia today, especially with the massive mining and agribusiness sectors driving so much of the economy? What does that mean for First Nations communities on their ancestral lands?
Unfortunately, it plays out in a deeply unequal and often exploitative way. Mining companies, for example, have a notorious history, as the sources put it, of not receiving free, prior, and informed consent, or FPIC, not receiving FPIC from First Nations communities before proceeding with projects. They are consistently criticized for disrespecting sacred sites, causing irreversible damage to cultural heritage, and for providing little or no benefit to these communities in terms of employment, economic uplift, or share in the immense profits generated from their land.
Little or no benefit despite living on resource-rich land.
Exactly. It's a crucial point.
Huh.
These communities are literally living on lands incredibly rich in resources, yet often remain marginalized, their connection to country severely impacted or severed. Our sources indicate the scale. Mining projects account for 14% of large-scale land deals globally in the last 10 years, occupying about 7.7 million hectares of agricultural land. Much of this impacts Indigenous territories.
Despite the Native Title Act, which was supposed to be a turning point, it sounds like there's still little or no protection from mining companies for Indigenous landowners. How does that work in practice?
It's quite concerning. It reveals the continued imbalance of power. In some states, for example, there's no requirement for an exploring company to even approach traditional Aboriginal owners directly if native title hasn't been formally determined for that specific area.
No requirement to even talk to them first.
In some cases, yes. Locals might tragically learn about provincial exploration activities only through vague newspaper advertisements. This lack of direct consultation immediately creates an uneven playing field. It denies Indigenous communities their fundamental right to self-determination over their ancestral lands.
And the Ward decision excluding minerals comes back into play here, too.
Absolutely. As we discussed, the High Court stating native title doesn't constitute resource ownership, excluding subsurface minerals, that signals a piecemeal erosion of native title. It separates surface rights from the immense mineral wealth beneath, which is the key driver for mining, granting miners access to the most valuable parts, while communities are left with a fragile claim to the surface.
So it's not just a lack of protection, but a legal framework actively facilitating extraction. Let's look at the mechanisms used today for engagement Indigenous land use agreements, or ILUAs. They've grown rapidly, especially with mining, but what are the criticisms?
ILUAs are indeed increasingly common. Agreements between native title holders, claimants, and others, notably governments and mining companies. But they face significant criticism for being imbalanced. Some agreements, as highlighted in our sources, have no commencement date and no end date, or in the alternative, have a start date but no end date, creating perpetual obligations and uncertainty.
Agreements with no end date.
Yes, tying communities indefinitely, often without adequate review or ability to adapt. Beyond that, they often contain open-ended indemnity clauses, meaning Indigenous parties could unknowingly accept liability for unforeseen environmental damage or future legal challenges, putting their limited resources at risk.
That sounds incredibly risky.
It is. And perhaps most concerningly, they include clauses seeking consent for validating unspecified acts necessary to give effect to this agreement. Indigenous parties are essentially agreeing to future actions without knowing their full scope or impact. This lack of clear terms, specific consent, and balanced liability opens the door to potential exploitation.
This sounds like an incredibly imbalanced negotiating environment, especially facing large, well-resourced mining corporations. What are the specific disadvantages Indigenous communities face?
The imbalance is severe. For example, under the Native Title Act's Future Acts regime, native title only gives traditional owners a narrow 6-month window to negotiate with mining companies. 6 months. If they fail to reach an agreement in that short time, maybe due to complexity, lack of resources compared to the mining giants, mining can proceed without any benefits flowing back to the traditional owners.
6 months or nothing.
Often it's a take-it-or-leave-it situation under immense pressure, forcing communities into unfavorable terms or no agreement at all. And adding to this, if new evidence appears after an agreement is signed, say, new archaeological findings revealing a sacred site, there's often no way back.
No way back.
The agreement stands, legally binding the indigenous party, potentially leading to the destruction of sites that new evidence could have protected. This inflexibility undermines the spirit of free, prior, and informed consent.
And the process just to get native title claims acknowledged sounds incredibly lengthy and burdensome, too.
It truly is a protracted struggle. Our sources reveal it can take decades, often far exceeding the lifetimes of elders who hold crucial knowledge. Even straightforward claims can take a decade or more. Contested claims average around 6 years. The very first native title claim, lodged in 1994, wasn't settled until 2010.
16 years.
16 years. And disagreements between Aboriginal groups, sometimes fueled by colonial interventions, can delay or derail claims further. There's also the deeply concerning issue that elders might be deliberately excluded from deliberations if their views conflict with others' agendas, undermining traditional governance.
These systemic hurdles just make accessing even the limited rights offered by native title incredibly difficult.
An arduous journey, yes.
Now, there's a common misconception out there, often fueled by media, that Aboriginal people receive millions of dollars for nothing when mining happens on their land. How does compensation actually work?
That is a very pervasive, damaging, and fundamentally misleading misconception. Compensation here is what the government legally owes Aboriginal people when it acquires their traditional country and extinguishes their native title rights. It's akin to how any private homeowner would be compensated if their property was compulsorily acquired for a highway, for example. It's not a windfall, it's a legal entitlement for loss.
Compensation for loss, not a handout.
Exactly. For centuries, this compensation was largely denied or minimal. However, there's a recent significant development. The High Court's Timber Creek decision. The court awarded significantly higher compensation, particularly for cultural and spiritual harm, which governments previously assumed would be small. This creates a stronger incentive for governments to negotiate more equitable settlements now.
So potentially a shift.
Potentially, it might signal a shift away from that fragile bundle of rights approach, giving more weight to the profound cultural and spiritual connection to land, increasing the cost of extinguishment for governments. A small but potentially significant shift.
So even with native title laws and some shifts in compensation, it's clear the system continues to facilitate wealth extraction from indigenous lands, often with minimal benefit or true consent, reinforcing that idea of an ongoing engine of primitive accumulation.
Yes, that seems to be the underlying dynamic described in the sources.
Okay, let's broaden the view now. This discussion in Australia, as challenging as it is, isn't isolated. It's part of a much larger global conversation on colonialism, its legacies, and the ongoing struggle for justice for Indigenous peoples worldwide.
Absolutely. And what's increasingly relevant are international frameworks that try to address these historical injustices. Take the UN Declaration on the Rights of Indigenous Peoples, UNDRIP, adopted in 2007. It took 25 years to negotiate, highlighting the global complexity. While it's not a binding treaty, it strongly influences national legislation and policy, providing a globally recognized standard for Indigenous rights land, self-determination, culture.
And Australia's relationship with UNDRIP has been complicated.
Yes, Australia initially opposed it, then endorsed it in 2009, reflecting those ongoing tensions between international standards and domestic policy realities. Then there's the ILO Convention 169 concerning Indigenous and tribal peoples. It emphasizes non-discrimination, equality, cultural diversity, autonomy. Its principles are widely acknowledged.
And a key element in these is free, prior, and informed consent, FPIC.
Yes, FPIC is crucial across these frameworks. It means before any development affecting Indigenous lands proceeds, there must be consultation in good faith, aiming for consensus, considering the people's lives, beliefs, institutions, spiritual well-being. This is far cry from newspaper ads or a 6-month take-it-or-leave-it negotiation window.
A very different standard. But despite these international standards, countries like Australia still face significant internal challenges in truly implementing them. What's happening policy-wise within Australia to bridge this gap, or perhaps to facilitate economic integration?
Well, in Australia, the 2015 COAG investigation into Indigenous land administration focused on areas reflecting this tension. Things like gaining efficiencies in rights recognition, supporting bankable interests in land, and improving processes for doing business on indigenous land.
Bankable interests. What does that mean in practice?
It involves considering removing legal barriers to creating bankable interests on exclusive possession native title land. The idea is to enable indigenous groups to use their land for commercial purposes, potentially requiring legislative reform to allow leasing as collateral for loans. It indicates a focus on integrating indigenous land into the broader market economy, which offers potential opportunities but also raises complex questions about control, risk, and potential exploitation if not truly indigenous-led.
A complex balancing act, as you say. There seems to be this constant tension between recognizing rights and facilitating mainstream economic development. You mentioned bankable interests and the challenge of land being inalienable. How does that paradox play out?
It's a critical paradox. It highlights the fundamental difference between indigenous and Western concepts of land. Sources suggest comprehensive settlements are often seen as a stronger foundation for development and reconciliation. They allow a broader approach than narrow legal claims and can resolve government's compensation liability. The Southwest Native Title Settlement in WA with the Noongar claimants is an example, though complex and lengthy itself.
But the land itself often can't be sold or mortgaged.
Exactly. Indigenous land and native title are mostly inalienable, meaning they can't be easily transferred, sold, or mortgaged like freehold land. This is primarily to protect the land from further dispossession, ensure its continuity, preserve that deep connection. But within a Western financial system relying on land as collateral, this creates economic hurdles, limiting access to capital. The question is, how do you foster prosperity while respecting a relationship with land that isn't about it being just a commodity?
A fundamental question. And stepping back even further, this entire discussion about land, resources, and wealth in former colonial states like Australia, it echoes a much larger transfer of wealth from the global south to the global north, doesn't it?
Absolutely. The sources make it clear. A significant portion of the ultra-rich's wealth, globally, isn't purely merit-based. They state 60% of billionaire wealth is inherited or acquired through favoritism, corruption, or monopoly power. This isn't just history, it's an ongoing process, a continuous global primitive accumulation perpetuating power structures. The wealth from these lands, mining, agribusiness, it's a direct result of this historical and ongoing dispossession, both locally and globally.
Shaping the global distribution of wealth today.
Very much so, demonstrating that colonial legacies are alive in our contemporary economic landscape. Settler colonialism, as seen in Australia, involved eliminating existing indigenous populations and taking their lands. Described as terrible crimes, immense in their violence and scale, with profound, lasting economic consequences. The profits extracted continue to flow, contributing to extreme inequality.
This context really drives home the broader call for reparations for colonialism, which seems to be gaining momentum. What does reparations truly encompass here? It's clearly more than just money, right?
No, it's far more expansive than just monetary compensation, though that can be part of it. Our sources define reparations as a call for justice, aiming for satisfaction, compensation for damages, rehabilitation, and preventing future abuses. This includes, first and foremost, explicit, sincere, formal apologies, not just from governments, but also companies, royal families, wealthy families who demonstrably profited from colonial systems and dispossession.
Apologies are a start. What else?
It involves establishing robust truth and reconciliation commissions, comprehensive investigations into the full impact of slavery and colonialism, including its gendered and racial justice dimensions, ensuring the true history is acknowledged. Furthermore, reparations advocate for democratizing land governance, prioritizing indigenous leadership, especially women, ensuring their rights, territories, ancestral lands are fully protected in all land policies.
So systemic change, not just gestures.
It's exactly.
But dismantling the lingering structures of colonial exploitation and building a more equitable, just, and self-determined future.
This deep dive truly shows that the fight for indigenous land rights and recognition in Australia is a microcosm of a much larger global struggle against the legacies of colonialism and for economic and social justice, revealing how primitive accumulation is a continuous, pervasive force. We've navigated a truly complex and, often unsettling landscape today. From the foundational legal fiction of terra nullius and the brutal policies of pacification by force, through the Maivo decision and the often frustrating limitations of native title, to the ongoing challenges faced by indigenous communities in the relentless mechanisms of resource extraction, it's crystal clear that the idea of Australia's national wealth being built solely on hard work needs a critical re-examination, especially when we consider the violent and systemic dispossession of indigenous peoples that formed its very foundation. Indeed. What we've seen is how laws and policies, even those like the Native Title Act intended to provide some recognition, have often been interpreted and applied in ways that serve ongoing accumulation of wealth for some, sometimes leaving indigenous communities struggling for basic rights over their ancestral lands. The denial of treaties, the reserves, forced assimilation, the continuous pressures from industries like mining. They aren't just historical footnotes.
No, they're active forces today.
Exactly. Active, shaping forces in the economic and social reality of Australia today, perpetuating the cycles of primitive accumulation.
It really makes you think deeply about the true cost of development and at whose expense that prosperity has consistently come. For you, our listener, we sincerely hope this deep dive has given you a more thorough understanding, an understanding of the deep, often unacknowledged roots of economic inequality and the ongoing fight for justice in Australia and, well, globally.
This raises an important question for you to ponder long after our conversation ends. If the wealth and prosperity of a nation are, in many ways, fundamentally built upon the dispossession of its original inhabitants, what would true reconciliation and economic justice truly look like? And how might pursuing such a vision fundamentally redefine our understanding of ownership and prosperity for the future, not just in Australia, but across the globe?